Hi, and welcome to Legal Affairs. My name is Diamond Liddy, and I'm the public defender for the 19th Judicial Circuit. I am very proud to have on our show our juvenile supervisor for the entire 19th Judicial Circuit for the Public Defender's Office, Brett Peters. So welcome, Brett.
Thank you, Diamond. I'm happy to be here.
We are going to be talking about juveniles, kids, children in the criminal justice system, but upcoming legislative proposals regarding juveniles, what has changed recently, how has COVID affected juvenile court, all of those things. But let's start with you, Brett. You are an assistant public defender first and foremost, correct?
That is correct, yes.
Okay. And in that position, you have, let's get back up a little bit. Tell us about yourself. Tell us about your schooling, where you came from, when you moved to the Treasure Coast, those things.
Sure. So I did my undergraduate work at Florida State University in Tallahassee.
Right.
Then I ended up going to law school at Florida A&M University College of Law in downtown Orlando.
Okay.
And while I was there at the law school, I took a bunch of courses in law. I took juvenile law, all types of things like that. And as soon as I graduated and passed the bar, sent out my application to you, got hired on a handshake, and I moved down to the Treasure Coast immediately. Now, since I've been with your
Where are you from originally?
Originally, I'm from Chicago.
Oh, okay.
Yes.
Okay.
Yes.
So that's where that, I should have, I know I knew that, but is that where you have an accent, and I'm just realizing it now.
Yes, there's a slight northern accent, a little bit of a swagger, if you will, and that's from Chicago,
okay,
absolutely.
Okay.
Yeah.
So go ahead. Go ahead.
So luckily you gave me the job at the Public Defender's Office, and I started off in juvenile in Fort Pierce.
Right.
Ended up handling a bunch of cases there, ended up taking something to trial, and then I went to Okeechobee County, which is under the 19th Circuit.
Yeah, and let's clarify that because on other shows, of course, we talk about the 19th Judicial Circuit, but the 19th Judicial Circuit, let's back up a minute. The state of Florida is broken into 20 judicial circuits. We're the 19th, and the 19th is made up of St. Lucie County, which is Fort Pierce, Port St. Lucie, Martin County, Indiantown, Stewart, part of Jupiter, Okeechobee, Martin, St. Lucie, and then, of course, Indian River, which is Vero and that area. So as an assistant public defender, obviously, you could be placed in any of the counties. So go ahead. I'm sorry.
No, absolutely. And that's one of the great things about working for a circuit like yours is that you could work in different counties.
Right.
And when you work in different counties, you're going to be working with different judges. So you're going to be getting all types of different types of experiences. In the long run, you're going to be so much of a stronger attorney.
Right.
And that's kind of the path that I took. I went to Okeechobee County, worked in the juvenile arena, also worked in the misdemeanor county court arena. Took cases to trial out there, gained more experience.
Right.
And I was there for a while. And then I came back to Fort Pierce for another go-around. And we had a great time in Fort Pierce. And this time when I came back, I was handling misdemeanors with, again, a different judge.
Right.
Again, trying cases in front of a different judge, learning more law, gaining more experience. And I was there for a little bit. And then I got transferred to Indian River County. And I started handling juvenile out there in circuit court. And then I started handling adult felonies out there.
Right.
And in front of a different judge. And again, started trying more cases, getting more experience. And I was out there for a while. And then, guess what? I finally came back again for another round in Fort Pierce. And when I was in Fort Pierce this time, I was doing felonies in circuit court. Again, trying cases, gaining more experience. And then I applied for the juvenile supervisor position when it became available, and luckily I got it. And here we are now.
Yahoo!
Right.
Yeah, which is a big promotion.
Oh, it's a huge promotion.
Yes.
It's amazing.
Well, you know, I think the viewers need to know that it's important. Adult court is very important. Obviously, the public defender's office handles only criminal cases, but does so in adult and juvenile court. But it's not that we give juveniles, you know, short shrift. It's not that the juvenile division, juvenile cases are not as important to our office. Clearly, and you can chime in here too. I don't mean to stop you, but just because you're a kid or a child in criminal court, the penalties in some cases, not all, are not as serious, but we take juvenile cases and treat them just as seriously.
Absolutely. My attorneys that I supervise, they take juvenile law extremely seriously. They take it very serious. We are handling very serious felonies that our juveniles are charged with. Granted, the penalties are not the type of penalties that they would get as an adult.
Right.
But nevertheless, these are very serious charges.
Well, and we need to point out, I think it's important, you know, back in the day, juvenile arrests and convictions were, I mean, now we're talking back in the day. There was a period, you probably weren't even born yet, where if you got arrested as a child, as a juvenile, and it was handled in juvenile court, it was expunged on its own 3 years after the conviction. Mm-hmm. I mean, nobody knew about it. You didn't have to talk about it on an application. It didn't wasn't scored in points in the guidelines.
Right.
Anything like that. Nothing could be farther from the truth now. Correct? It's serious.
It is very serious. It's one of the things that my attorneys and I always advise juveniles when we handle their case of, hey, look, you've been charged with this type of felony. Now, the penalties right now might not be as serious as you were charged an adult, but guess what? One day you might be charged an adult.
Right.
And do you know what they can do? They can use this charge on your score sheet as an adult against you.
Right.
This will increase your punishment or your lowest permissible sentence.
Right.
Right.
And again, you oversee, and because I want to talk a little bit about, you oversee all of the juvenile division in the circuit, correct, Brett?
That's correct.
Okay.
So I oversee all the attorneys from Indian River County, Martin County, Okeechobee County, and directly here in Fort Pierce, St. Lucie County.
And let's back up, I guess, for a moment. I do want to talk about, the big difference that people may not be aware of is that in juvenile court, although you have jury trial experience, obviously, from all the different counties and courtrooms you've been in, God bless you. But the main difference between juvenile and regular court, county court, misdemeanors or felony court, is that there are no jury trials, correct?
That's correct. So back in, I want to say it was around the 1960s, there's a very, very famous Supreme Court case called In re Gault. And In re Gault essentially said, hey, juveniles are entitled to all the same type of protections that an adult is. We're talking about court process, right to an attorney, due process, all those types of things. The only thing that the juvenile is not entitled to is a jury trial.
Right.
That's the biggest difference between adult court, which obviously they are entitled to a jury trial,
Right.
and juvenile land, they're not. So the judge, he is going to be your jury. The
Right.
judge will listen to both sides and decide whether or not you committed the delinquent act.
Right. And again, as a juvenile, if you are, give us an example of a child who's gotten in trouble, keeps getting in trouble. There is a mechanism, if you will, is there not, to take a child, and that's a person under the age of 18, into adult court and punish them, even though they're 16, with adult sanctions, correct?
Absolutely.
Okay, let's talk about that, because
Sure.
people need to know how serious this is, and how you don't have to be a frequent flyer, as we call them in the business, or if your charge is serious enough, you can go at 17 into adult court and go to state prison, correct?
Absolutely.
Okay, let's talk about that.
Sure. So there's numerous things to talk about in this area, but I think the most important one that we should really address is what's called the direct file statute. Now, what the direct file statute essentially says is, if a child the age of 14 years old or 15 years old commits a list of enumerated crimes, we're talking about your nasty crimes, right?
Right.
Robbery, those kind of things. If a child commits one of those, the state attorney's office has complete discretion to say, you know what, we don't think he should be handled as a juvenile anymore. We're going to charge him as an adult. And it's completely up to them.
Right.
And
that's been, I want you to go on, but I have to interject, because we talked about this recently because
Yes.
of a forum that I was involved in. There's been bills up before the legislature to change that, to take it out of the sole discretion of the prosecutor, but they just haven't gotten any traction, correct?
they haven't, and it's something that anyone that's a juvenile advocate is constantly pushing for.
Right.
We would like the decision to be up to the judge or up to a jury.
Right.
Let them make the determination of whether or not they think that we should charge a juvenile and treat him as an adult, charge him an adult. But
Right.
unfortunately, at this point in time, the statute clearly allows the state attorney's office to have sole discretion.
Okay. Okay, so go ahead, and I'm sorry, I wanted to interject that.
No, that's okay. So when a juvenile is 14 years old and they're alleged to commit one of these enumerated crimes, the state attorney's office can charge them as an adult. When they're 15 years old, the same thing.
Right.
Now, once they turn 16 years old, then the state attorney's office has much wider discretion. They can charge them as an adult for pretty much any type of felony at that point.
Right, it doesn't have to be one of the enumerated.
Correct.
Okay.
Right. So it's a nasty statute, and it's extremely serious. It's one of the things that I teach my attorneys when they meet a client, a juvenile client, hey, you need to tell your client, don't try to scare him, but let him know this could possibly go upstairs. We call it upstairs. This could possibly go to adult court.
Right. No,
you
I
could be
gotcha.
charged as an adult. So be careful. We need to try to resolve your case sooner rather than later. We don't want you picking up any more charges or anything of that nature. So it's something that we take very seriously.
Well, and again, I know you're not finished. Let's say it's a robbery, an armed robbery. So one of the enumerated offenses, and the child is 15. Okay. Do you have negotiation power? Are you able to talk to the prosecutor about upfiling, if you will, to adult court before they make that decision, or is that made without any input from you?
Well, so that's one of the goals, and one of the things that I teach my attorneys is spot it right away. Spot it as soon as they get arrested. Contact the state attorney on the case.
Right.
And say, hey, what could we work out inside juvenile court?
Right.
and try to just get on the ball immediately before the state attorney thinks to himself, well, you know what, I'm going to go ahead and direct file.
Right.
So we try to negotiate as soon as possible to come to a resolution in juvenile land.
Well, let me give you another scenario. We've got a child, you call the prosecutor and say, look, please don't upfile it, don't direct file it into adult court. Let's work something out in juvenile court so they don't have an adult record. And I'm ahead of myself. Once they're in adult court, are they always in adult court?
Yes.
Okay.
Unfortunately, so how it works is once they're charged as an adult on a felony, then the law clearly says that everything else that they have going on, you can't go back. And if they have other felonies that are outstanding right now, those need to go up into adult court as well.
Okay, okay. Now, so just increases the severity and seriousness
Absolutely.
of it. What about your prosecutor that you're working on? You call them, talk to them, and they say, well, I'm sorry, Brett. I'm direct filing into adult court. And other things come to light that, you know, you as the defense lawyer brings to their attention. The victim does not want the child punished in that manner. At that point, before they are convicted in adult court, can it go back to juvenile court?
That's a great question. I think that there would probably have to be some type of a motion filed, probably by the state attorney's office, maybe a stipulated motion with agreement of all parties. That being said, when a juvenile does get charged in adult court, the felony attorney handling the matter could always ask, well, not always, but most of the time, could ask the adult felony judge if we could impose juvenile sanctions.
Even though they're convicted in adult court?
Yes.
Okay.
Yes.
Okay, so that's an option as well.
Absolutely.
Okay. Let's talk for a moment, Brett, about juvenile sanctions, because people don't understand the difference.
Sure.
Juvenile sanctions versus adult sanctions. Now, we all know adult sanctions are things like prison, county jail, probation, community control, house arrest, those kinds of things. Give us some idea of what juvenile sanctions would be.
Sure. Before we do go into that, though, I think it's important that we kind of understand the biggest difference between juveniles and adults and what we're trying to accomplish. With adults, the primary goal, unfortunately, they're trying to accomplish punishment.
Right.
Right? Rehabilitation is up there as well, but it's not the primary goal.
Right.
With juveniles, the primary goal is rehabilitation, not punishment.
Right.
So with that being said, now we can kind of compare and contrast the difference.
Right.
With juveniles...
And that's... everyone needs to know, it's not that you as a defense lawyer are advocating, let's rehabilitate a child because they're a child versus an adult. It's the law. It's the intent of the statute. In adult court, the primary purpose is punishment. We know that, although rehabilitation is up there as well. But in juvenile court, the law is, let's try and change this child. Let's try and help them so they're not back within the system again.
Absolutely. If you open up the statute, Chapter 985, right at the beginning, it says the purpose and intent of the statute, and it says the legislation's intent is to rehabilitate the child.
Right. Okay.
So it's crystal clear.
Yeah, it's not you, it's the law.
Yes, absolutely.
Okay.
Right. So with juveniles, there's really two areas that they can go into as far as what they're going to get sentenced to, or in juvenile court we call it the disposition. One area is what we call probation.
Oh, and that's important to know too. In adult court, you get sentenced. In juvenile court, it's a disposition, which is similar to a sentence. So we're educating everybody here so they know the terms and terminology.
Yeah, absolutely, right.
Okay.
In adult court,
right,
you get sentenced, and you go to a sentencing hearing. At juvenile court, you go to a disposition hearing.
Right.
Right. And another thing to point out is adults, they commit crimes. Juveniles commit delinquent acts.
Okay.
Okay? So anyways, going back to what we were talking about earlier, one option the judge has is to sentence the juvenile or give him a disposition of probation. Probation, he's going to keep them in the community, he's going to keep them with their family at
Right.
home, and he's going to give them some sanctions to work on. Community service hours, some rehabilitation goals such as anger management classes, perhaps their substance abuse issues, family counseling, things like that.
Right.
So that's one option the judge has at his disposal. The other option the judge has is the judge can say, you know what, I think that you need to go to what's called the DJJ, Department of Juvenile Justice, residential program.
Okay.
Now these programs, they're anywhere in the state of Florida. And the juvenile lives there, he eats there, he sleeps there, he goes to school there also, but he doesn't go home. And there's multiple levels of programs depending on how serious they think the situation is.
How many levels?
So they have what's called the minimum risk program that's still in the community. The main levels are your non-secure residential program, your high-risk residential program,
Right.
and your maximum risk residential program.
Okay. And do we have those programs in our circuit?
We do.
Okay.
We do have some programs in Okeechobee County, and I think that's about it as far as the 19th Circuit, correct?
Right.
Yes.
So if they get sentenced to, if they get, their disposition is not just pure probation or disposition within the community, and they go to the high risk, et cetera, the different levels, they could end up because of space, correct?
Correct.
In Ocala, in Pensacola, I'm saying those cities because, and I don't even know if they have, detention centers up there. But I mean, they could be sent anywhere in the state, correct?
Absolutely.
Okay.
Anywhere in the state. The judge doesn't have control over where they go. I've worked closely with the 19th Circuit commitment manager, and he specifically has made it clear to me their goal, they try to get them as close to their house, to their
so
families
the
as
family
possible.
can visit.
Correct.
Okay.
Absolutely.
Now, how long can this disposition sentence to a high-risk facility last?
Sure. So legally, they can be in one of these programs all the way up until their 21st birthday. Now, that being said, they have average ranges. So for example, at the non-secure program, the average stay at that program is about 6 to 9 months.
Okay.
They also have a high-risk program. Depending on who you talk to, I'd like to say that the average in there is about 12 to 15 months. And then they have the maximum risk program. The average stay at that can be 18 to 36 months.
Wow.
But it's one of these programs, they're made for the juvenile or the youth to get in there, work the program, get your counseling,
get rehabilitated.
get your
hopefully.
counseling, get your help, get your rehabilitation.
Right.
The faster you work it, the faster you're going to get out.
Right. Oh, so you're saying then, Brett, if they're sentenced by the judge to 18 months, they could conceivably get out sooner if they do great?
Absolutely. So
Okay.
the judge would never say, I'm sentencing you to 18 months into one of these programs. That would kind of be something that they would say in adult court.
Right.
But what the judge would say is, I'm sentencing you to a high-risk program.
I got you. And then they decide based on how engaged the child is, how much, they seem to have changed, rehabilitated, or whatever. So the amount of time is really in the child's hands.
Absolutely.
Okay.
Absolutely. And then how the process works is that the people at the program would submit what's called a progress report to the judge.
Okay.
And they would say, hey, we recommend that he be released.
To the
from
original judge.
To the original judge.
Okay. And do you have input on that?
Unfortunately, I don't, because our office only represents the juvenile for such a period amount of time.
Right.
And usually this happens at such a farther,
Right.
I'm so far removed. But whenever I happen to be in the courtroom and I see that one of my youths is in there for review, absolutely, I'm going to jump on it.
Right, sure. This show goes so fast, and there's so much more we need to talk about.
Okay.
We got about 3 minutes left.
Okay.
Let's talk from the heart for a moment. You obviously have been all over the circuit.
Yes.
And you've handled, adults, kids, misdemeanors, everything. So you have a real alchemy of experience. How do you feel about representing children?
I love it so much, and I'll just try to put it into words. There's nothing that feels better than meeting a youth, and it's their first time they've done something wrong.
Right.
And because I have the experience in the adult world, I get to have this nice, sit down in my office and talk to the kid and say, hey, look, this is a path you could go on, and this is another path you could go on.
Right.
And based on my experience, let me tell you the path that you want to avoid. And recently, I actually met a youth, a juvenile that I had represented, and I ran into her, and she actually told me, hey, Brett, I'm enrolled, I'm going to college.
Oh.
And I was just, it was just lovely. It's great. It's great.
It makes it all worthwhile.
It really does. I just feel like we get so much more of just an impact, and we're able to kind of influence them and just get them some good quality guidance. So I love it.
Well, and you're, with the, so many of these children are not so tainted,
No.
so influenced, so bad that they can't change and turn their lives around.
Absolutely. I mean, these are kids.
Right.
Right? These are kids.
And you can't ever, you can't forget that, can you?
No.
Yeah.
No. These are kids, and kids don't have the capacity to fully appreciate the consequences,
Right.
short-term and
Right.
long-term, of what they're doing.
Right.
And you need to understand that as an attorney when you're talking with them.
Right.
You know?
It's, I guess the beauty of representing juveniles in court is that if you're doing this work to make a difference in the world, there's no better place to do it. Correct?
Absolutely not. This is the creme de la creme. I mean, this is the Taj Mahal. This is what you want to be doing. If you love working with kids and you want to help shape kids' futures and look out for their best interests, being a juvenile attorney is what it's all about.
Okay, well, this has been wonderful. You've given us a broad spectrum. You got to be on the show again because we got to fill in all the blanks.
Absolutely.
But this was great.
Great.
Thank you. Keep up the great work.
Thanks.
Okay.